Vegas, how you doing? This is Bryon Watkins coming back at you with another show. It's my second show that I'm doing right now. The first one I did, I was interviewed. This is my second show on my own. So I want to talk about more unlawful stops by police, unlawful detainments by police, which is essentially false arrest by police. Today, right now, is Tuesday, I do believe. I hope I get that correct. Just excuse me 1 second, so I want to make sure that I have them saying. Yes, Tuesday, July 11th, 2017. But first of all, I want to read to you from a book, one of my favorite books, and I would encourage you all to start reading books by judges. I don't care if some people may say, well, I'm not going to read that book because it's too conservative, or I'm not going to read that book because it's too liberal. So what? Read it anyway, because you'll be amazed you can get from different mindsets. That's the point. Now, I'm going to read to you from this book right here. The title is Reading Law, the Interpretation of Legal Text by Anton Scalia and Bryon A. Garner, the late United States Supreme Court Associate Justice Anton Scalia. He's a very good writer. Some people may not like him, but trust me when I tell you, with an open mind, he's a very good writer. Now, in the page 7, the introduction to this book, it reads as follows. More serious, perhaps, than the fact that some judges knowingly persist in acting as lawgivers is the fact that many judges who believe in fidelity to text lack the interpretive tools necessary to the end. American legal education has long been devoted to the training of common law lawyers and hence common law judges. And with that said, a lot of judges and a lot of attorneys don't enforce common law. Common law will be another show at a later date. But I'm sure a lot of you already know about common law and have heard the term and so forth. But I'll continue. What aspiring lawyers learn in the first formative year of law school is how to discern the best, most socially useful answer to a legal problem, and how to distinguish the prior cases that stand in the way of the solution. Besides giving students the wrong impression about what makes an excellent judge in the modern democratic text-based legal system, this training fails to include the skills of textual interpretation. What students learn about the canon of interpretation and other principles of textual construction that learn haphazardly when reading cases in such text-based courses as tax law, securities law, employment law, environmental law, administrative law, and criminal law. But this is the part that got me, which doesn't surprise me after interacting with attorneys and hearing attorneys speak, even some judges. Even so, a noted Harvard Law professor, Mary Ann Glendon, Glendon, has said, most of our fellow citizens, no doubt, would be astonished if they knew how little training the average law student receives in dealing with enacted law. I'm not surprised, not anymore. And when they say when dealing with enacted law, the definition of that is laws that's already been enacted, that's already been implemented by the state legislatures, United States Congress, so forth and so on. When your authors, as an experiment, asked a group of 600 lawyers about if they knew the meaning of, this is a Latin word, so I'll spell it, I can't pronounce it, EJUSDEMGENERIS, 2 different words. One of the oldest and most frequently applied canons, only about 10 has sufficient confidence in the answer to raise their hands. 10 out of 600. Not good. So the problem is this, and I'm preaching to the choir with some of you. A lot of attorneys don't know the law like they think they know. A lot of attorneys have not been taught the law like they think they have been taught in law schools. But with that said, let me say this first. I'm going to get back to that. I've noticed in my experience, and as many of you have, when you are debating with attorneys, even some police, even some judges, one of the first things they always say, I wish I had a dime for every time I've heard this, well, did you go to law school? See, what they're really saying is, in the back of their head, okay, this guy or this woman's kicking my butt, so let me try to do something to throw them off their square. Let me try to do something to see if I can belittle them and bring a confidence level down. See, the thing about law school is this. I've vetted some law schools. Laws are easy to comprehend. There's nothing hard about them. It's reading, writing, and comprehension. That's it. Nothing more, nothing less. And what astounds me to this very day, how people want to come up with this most asinine comparison between a license by a doctor versus a law license. The law license doesn't exist, by the way. The Supreme Court has said that many times, but that's later. You cannot compare someone who has to work on a human body, human anatomy, with thousands of cells, various organs, blood work, all kinds of stuff. That becoming adequate in health in the medical field to be a doctor, that's up here. Whereas the so-called law school, that's down here. You can't compare the two. So when people try to compare the two, I think to myself, this individual must be a new kind of stupid. I don't know. I have no idea. So where they get these myths, these comparisons from, I have no idea, but they need to stop. They sound beyond ridiculous. It's dumb. Period. Point blank, period, the end. So with that said, let me go back to what I was talking about regarding as far as the law schools and the laws and so forth. Don't get it confused when they say law school. Don't get it confused just because it says law school, they're actually teaching law. Just like a lot of us already know, for example, I'm kind of digressing, but I need to make this just a bit of comparison to be quite honest with you. When people hear the word or term Federal Reserve, they automatically assume that it's under federal guide. Not true. They throw that name up there to confuse the public. Just like a law school, they really should name it Statutes and Codes School, or they really should name it Commercial Law School, because that's what they're actually enforcing our commercial codes, which they can say law. So don't get confused. Do not get intimidated when you walk into some law library and see an enormous stacks of books, and so are their books. Read them. Open them up and read them. So they're not teaching the actual real de jure, D-E-J-U-R-E law, de jure laws. They're teaching de facto statutes and codes law. Big difference, and it's altogether different. And that's going to be a show in and of itself, because you all really need to know the difference between the two. So, getting back to laws and lawsuits and so forth. If you ever get really deep into this stuff, debate with some attorneys. You'll be amazed what they don't know. You will really be amazed. It amazes me that a lot of attorneys that I've spoke with and debated with, they don't even know every state has its own constitution, nor why. I'll say that again. A lot of attorneys that I've spoke with and some that I've debated with, they don't even know that every state has its own constitution, nor why. That's extremely important to know. Very, 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 very important to know. So, with that said, my show yesterday, and this is my second show, so and it's going to get better. I'm going to have topics like nailed down to the T. So just bear with me. Now, yesterday my show was about stop and frisk by the police. Well, first of all, let me say this, because some people, we've all heard it before. Why are you all beating up on the police and hating on police and blah blah blah? I don't hate the police. I hate their process. I hate their procedures. I hate how they do things, because there are a lot of cops that do the right thing. Thank God there's a lot more than there's not. But unfortunately, it's the bad ones, the idiots, that gives and that has given to this very day that profession an enormous black eye the size of Mount St. Helens and then some. I mean, that profession has such an enormous black eye. They need to have a lot of they need a lot of healing. It's as simple as that. They do. And then the administration that covers up for them, that makes it worse. It does. So, with that said, I'll move on. The reason I do this, because people need to know not only the laws, they need to know how to defend themselves. Read the Founding Fathers, what they said, and also study great leaders before them. They always, the crux of their passion was for people to learn how to defend themselves. And the only way you can know how to defend yourself is to know what the laws are, is to know what the procedures are, is to know not only to ask questions, but to know what questions to ask. Therefore, asking the right questions. And that's going to go along what I'm about to talk about right now. And it's called pretextual stops by police. Now, let me say this first. I don't want to forget this. If you have any questions, you can call in the number 702-984-6843. 702-984-6843. Now, a pretextual stop. And I'm going to post this. I'll put this up here right here so if you all can see it. I write down a lot of stuff. I have a large library, if you will, with a lot of stuff I've been working on for the past 5 straight years. Yes, that's how long I've been doing this, 5 straight years. But I will say with confidence, the last 3 has been dead on. When you start out on something, you're new at it, you're green at it, you're going to make mistakes, and you want to make mistakes. That's how you learn. So, a pretextual stop. A pretextual stop, for example, is if a police pulls you over and claims you didn't signal right, or claims you crossed a double line or whatever. That's a pretextual stop. It's a stop that they're using. I mean, it's the reason they're using to stop you. A pretextual stop. So, one court case recently is a very good court case, and people are misinterpreting it wrong. Utah versus, I can't pronounce the last name. It's STRIEFF. Citation number 579 US 2016. That's the year it was decided, last year. In that court case, and this is already prior before this individual was stopped, a house the police were looking at was, they had very good tips on it was a drug house. Turns out that it was. Well, first giveaway is constant traffic in and out. That's the first giveaway. So police one night was watching the house like they've been doing prior to this gentleman that they stopped. He leaves the house, he goes to a convenience store, and they stop him, question him, ask him what he's doing there, etc., etc. Fast forward, come to find out they had drugs on him. So they arrested him, charged him, and he was convicted. He tried to have the exclusionary rule used to have the drugs thrown out because he says he was stopped in violation of the Fourth Amendment because they had no reason to stop him. That's not true. And this part I do agree with the police. And this is very important for you all to use. So listen, so pay attention to what I'm about to say. Pay close attention to what I'm about to say. The reason the police had authorization to stop this individual because, again, they were already conducting a lawful surveillance on a house or building, what have you, before this gentleman even came into the picture. They were already looking at it. So, and the fact of the matter is, he was part of that ingoing, outgoing traffic. They had a right to stop and ask him, what are you doing? They didn't have to say, well, we've been conducting an investigation. They're not going to say that. But the police at the time, their bus was covered. So he tried to get it overturned. It didn't get overturned. So here's the thing. And some Supreme Court justices were highly disagree with it, or a disagreement with it. No, I agree with it wholeheartedly. And here's how you use it to your advantage. Now listen to me. Say, for example, you're traveling on the street, and they pull you over on a pretextual stop, saying you did signal. First and foremost, that's hearsay evidence. If I didn't signal, how can you prove that? Do you have a camera on the front of your cruiser that actually shows me not signaling? Because I say I did signal. You, police officer, said I didn't signal. I say that I did signal. That's hearsay evidence. But nonetheless, that's a pretextual stop. They came up with something to use to stop you. And then, a lot of people don't know this, they'll go and escalate it that much further and say, okay, if you step out of the car, we're going to search your vehicle, blah. They can't do all that. They can only question you on why they're stopping you. They can only search your vehicle if they have reason to believe that because of that stop, there's some kind of weapons involved that can harm the police officer, which I agree with. But if they're only pulling you over for allegedly not signaling, what does not signaling, turn on a blinker, have to do with something that may be harmful to you inside the vehicle that's related to you not signaling? Nothing. So at best, that should have been a citation, which is not really, but I'll discuss that later, and then on your way. So, my point being is this, and in conclusion, when it comes to this court case, if they say, well, we stopped you because of this, that's why we searched your car, this and that. No, because in this court case, the police were already conducting some kind of illegal activity. Illegal activity meaning with some kind of drugs or anything else involved, that's possibly people have been damaged or harmed. Someone not signaling, no one was harmed during that part at all. If in fact you did forget to signal, which again, that's hearsay evidence. In Crawford versus Washington in 2009, I think it was, the Supreme Court decided 9-0. Hearsay evidence is not admissible. They made that clear. Not just in that court case, but the other court cases. But I just wanted to throw that out there because it is hearsay. Just because a police officer is saying that, I don't care if he was the chief of police, the sheriff, the prosecutor, the attorney general, governor, president, rolled into one. At the end of the day, it's still hearsay evidence. I don't care who is saying it. It is hearsay, unless you have other evidence besides your mouth saying hearsay evidence. It's an opinion. Unless some police have cameras on their cruisers that actually saw that car not signaling, different story. Altogether different story. Now you have evidence. A camera. So the bottom line again, a pretextual stop, they can stop you if they know for a fact there was some kind of crime involved prior. And as a court case, I forgot right off, but I said traffic citations, those are not criminal acts. So they cannot say in court, well, I stopped you because you violated a crime or you committed a crime. What was that? Well, you did a signal. That's not a crime, it's a traffic infraction. Big difference. See, they try to use a lot of the terms interchangeably. They try to incorporate statute and infraction and penal code with law. No. Here's law, here's penal code, here's statute, and here's infraction. All different definitions. Law supersedes all. Bottom line is, if something they're dealing with is lawful, like a possible drugs, high-powered weapons, stuff like that, different rules and laws apply when it comes to the law. But infractions and penal codes, there are rules to decide if you actually committed an infraction or violated a penal code. Does not supersede law, which is much higher than these. It crushes all of these. And explaining this stuff is very easy to articulate. Some people like to give this elongated speech and try to build a mountain out of a molehill. Screw all that. Keep it simple. KISS. Keep it simple, stupid. So if they pull you over, just like, for example, stop and frisk on the street. Or if they stop you, this happens a lot. It's probably happening right now as I'm speaking to you all. Okay, where are you going? They said, we're stopping because we don't know where you're going. Well, I'm just going up the street. Okay, do you have any ID? Right there, that's a violation. When police do that, if you read the definition of the terms, that is actually called an unlawful arrest. Anytime police stop you and they do not have the proper reasonable suspicion to stop you, that is an unlawful detainment. An unlawful detainment, like I said yesterday, or day before yesterday, anyway. An unlawful detainment is when police stops you in a way to prevent you from moving and prevent you from, and a court case uses, will prevent you or deny you of your locomotion. Literally, that word, like a locomotive train. Well, same thing. Court case says if they deny you of your locomotion, your movement, your freedom to travel, your freedom to move, that's an unlawful detainment. That's illegal. If they don't have the proper articulated facts and reasonable suspicion and probable cause, the three inchoate acts within reasonable suspicion and the three articulated facts within probable cause, they'll stop you to begin with. That's an unlawful detainment right there. That's a felony. That's a lawsuit, and they will lose. Have no reason to stop you. And like I said, like I always stress, with police don't get this. I don't know why. People want to be left alone. It's as simple as that. That is not hard to comprehend. And if it is hard to comprehend, well, then I suggest for the police to obtain additional training, read some books. I don't know. And like many of you, I know you want to be left the hell alone. Not just by police, it's anybody. You're going about your way, minding your own business, not harming anybody. Leave me the hell alone. Period. It's that simple. And then some people will say, oh, well, Bryon, well, just listen to the police, obey orders. But no, not obeying nothing. When you have no reason to bother me. If anything, you obey me when I say leave me alone, because that's my right. That's my godly right. It's that simple. So, when it comes to pretextual stops, there's a few other court cases that describe pretextual stops. And believe me, you can use these to your advantage. If you're stopped on the street, you're in the car, and you know for a fact, only you will know this, but say, for example, you know for a fact you have no reason to stop you to begin with, the first thing you're going to ask, okay, are you investigating the crime? Ask the police. What's the nature of my stop? Well, I pulled you over for this and this. Okay, are you investigating a crime at all whatsoever that you think I may or may not have been involved in? Well, no, okay. Right there, they just sunk themselves. Because they're going to answer you. And that's, again, this is very important. That's why I'm stressing this. A pretextual stop. If they know for a fact that you were involved in some kind of alleged crime, or you're coming out of a drug house, or some kind of house that involves terrorist activity, something to that effect, and you're coming out, if I'm a cop, I'm going to stop you, because I don't know who the hell you are. And while you're coming out of that house, that's already been, prior to me even first laying eyes on you, has already been proven to be some kind of terrorist activity, or some kind of a major drug house, or some kind of whatever. That's fine. That's cool. I agree with police on that 100%, 1,000%. But if they stop you on the street or stop you while you're traveling in your own automobile and they have no reason to produce or perform a pretextual stop, they're done. Dead in the water. It's over. That's the point I'm getting at. So, with that said, I'll move on to another one. And many of you have seen this YouTube video. I'm sure you have. George Brunch from the Virginia Beach Police Department, on cop himself, talking with law professor James Duane's presentation called "Don't Talk to Police," and they gave us like a 2-hour, very good video. And I agree, don't talk to police. And that's the funny part. A lot of police even say, "Don't talk to police." So you're hearing it from the horse's mouth, and we all know the reason why, because they like to fumble up words, make you think you said something when you didn't, get you to say something that they can use against you. You had nothing to do with no alleged crime whatsoever, and they can take advantage of it and twist and turn it, and then give it to the jury. The jury has no idea what the hell's going on, so they technically essentially lie to the jury because they omit words and evidence. Omit words. And when you omit something, omitting is the same thing as lying. Deception is the same thing as lying. They don't have to outright say a lie, but if they deceive by not omitting everything, not admitting everything, they use omissions, that's lying. If they leave something out, that's lying. That's what I'm trying to say. If they don't say everything, they kind of say half things, half truths, same thing as lying. If they don't say anything at all, that's lying. Same thing. So, and to go further, and the stop and frisk is very important because that's where it starts. It's the stop and frisk. Now, let's talk about IDs now. The same thing. It goes back to pretextual stop and frisk. A lot of people don't know this as well, and there's many court cases that's proven this. If they're stopping you, and again, you're in that situation, so only you know. If you know for a fact that you're minding your own business, that you have not committed no crimes whatsoever, and they stop you, and they keep forcing you to give your ID, you don't have to. You do not have to. They'll lie to you and say, well, you have to get your ID. Then they're going to come up with a way to arrest you for not giving your ID. No, you do not have to give ID whatsoever. Because again, if they don't have the reasonable suspicion, and I'm gonna keep talking about this because people don't know this or the power of it. If they don't have the 3 employee acts and the reasonable suspicion followed by the 3 articulated facts and probable cause, you don't even have to give ID because it should not have stopped you to begin with. And them stopping you when they have no legal or lawful right to stop you, that's what, like I said earlier, that is an unlawful detainment because they're preventing you from your own movement. They're preventing you from your own travel. They are preventing you from your own locomotion to do freely as you wish when you have not committed no crime. It's as simple as that. And it goes on. And I give you another example. The major court case right out here in Nevada, which you can still use because I went to the Supreme Court, but you can use any court case from any part of any jurisdiction. I'll explain that later because that has to do with the full faith and credit clause. In closing, Hibble versus the 6th Judicial Court, District of Nevada, number 542 U.S. 177, 2004. Hibble refused to give up his ID, but what Hibble did not know, there was a confrontation, a domestic call against him by several people describing the truck. The Nevada Highway Patrol saw the truck, and they stopped him. So they had a good pretextual stop to stop him because of an alleged crime. Domestic violence, which is very big in our country, you know that, around the world. So that case, they were justified in stopping him, and he was proven wrong. But again, you use that court case like the other one at the beginning of this of my lecture to use to your advantage to prove, hey, I didn't commit no crimes whatsoever. Okay, so that said, I have to go. This show had to be short, so I have some errands to do, some more stuff to get together. So anytime you have any questions, call in, and I'll be more than happy to answer any questions that you may have or any court cases that you're going through. With that said, you all have a good day and stay hydrated because it's very hot today. Thank you.